Yeah. What's that in? problem with it.
I need a vote. Sorry. How are you doing?
I'm doing good. How are you?
Oh gosh, so
Yeah.
freaking
How are you, sir?
busy. It's
Y'all doing all right?
ridiculous.
Good. How are you? Good. We have the crazy congressional race going on.
Oh gosh, I can't imagine. Lord have mercy.
Yeah.
Yeah. I've read some commentaries here and there. Like, damn, I'm glad that's not my district.
I'm actually trying to stay out as much as possible, honestly. But,
Yeah.
yeah.
Well, of course, like the governor's race, like there's a lot of that going on in my county too. I'm sure it's happening everywhere. I'm personally just not going to endorse anybody, and so there's just a lot of pressure. Like, people are like, "Why aren't you?" Like, well, because.
Zero 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 32 or 3200.
On.
Ladies and gentlemen, welcome to today's meeting of the Government Operations Committee. Today is August the 20th. Clerk, please take the roll.
Senators Bowling. Senator Bowling is present. Senator Crow. Senator Crow is present. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Rose. Senator Rose is present. Senator Seal. Senator Sutherland. Senator Sutherland is present. Chairman Jackson. Chairman Jackson is present. Representatives Clemens. Clemens is present. Crawford.
Present.
Crawford is present. Faison. Faison's present. Fritz. Fritz is present. Glenn. Hardaway. Helton Haynes. Helton Haynes is present. Mayberry. Mayberry is present. McKenzie. Parkinson. Reedy. Reedy is present. Renault. Renault is present. Rudder. Rudder is present. Sherrill. Sherrill is present. Towns. Chairman Lafferty.
Present.
Mr. Chairman, Chairman Lafferty is present. Mr. Chairman, you have a quorum in both chambers.
Thank you for that. And members, before we begin with the business, are there any personal orders or announcements? Seeing none, just for me, quick hats off to the kids playing baseball today. I love me some Little League baseball, and it's an indication that football season's just around the corner. So yeehaw for that. It's let's members of the audience, there is a sign-up sheet on the table up front. If anybody wishes to speak, please make your way up there and get your name on the list, please. Members, there are a couple of rules we have on consent today. Those are items 15 and 16. Without any objection to those two, we will go ahead and ask for passage on consent. Any objections? Seeing none. Need a motion? We have a motion. Oh, I'm sorry. Do we have any public comment on the consent calendar? Seeing none. I have a motion and a second. Mr. Clerk, if you would, go ahead and take the roll in the Senate.
Senator Bowling?
Aye.
Senator Bowling votes aye. Senator Crow? Senator Crow votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Senator Rose?
Aye.
Senator Rose votes aye. Senator Seal? Senator Sutherland? Senator Sutherland votes aye. Chairman Jackson?
Aye.
Chairman Jackson votes aye. Mr. Chairman, you have 5 ayes in the Senate.
Thank you for that. And in the House, all those in favor indicate by saying aye. Any opposed? And the ayes have it in the House. Passes through both chambers with positive recommendation. All right. We've got top of the order here. First item of our agenda is the emergency rule by the Board of Medical Examiners. If you guys would like to come on up. And folks, we're having some issues with microphones today, so you will be responsible for pressing the button down there in front of you. Having said that, when you're ready, please go ahead and present your rules.
Thank you, Chairman. My name is Holt Wood. I'm Assistant Commissioner for Legislative Affairs of the Department of Health. I'm joined by Ms. Francine Baca-Chavez, who serves as General Counsel for the Board of Medical Examiners, and Dr. McLaren, who serves as a board member. These rules are being proposed as emergency rules so that the Board of Medical Examiners and the general public have a clear understanding of different statutes and their impact on individuals who choose to practice or apply to practice in this state. This rule eliminates the inactive licensure status and licensure inactivation fee, establishes criteria for a short-term visitor clinical training license, establishes a process for issuing a foreign training license of limited duration to international medical school graduates, and establishes a process for issuing temporary licenses of limited duration to an international medical school graduate. With that, we'd be happy to take any questions.
Thank you for that. Members, do we have any questions about the rules before us? Representative Fritz, you're recognized, sir.
Thank you, Mr. Chairman. Thank you all for your time today. Just a quick question on page 17 and 18 of the rule changes. And item number D, 13D1, asks for an attestation. And then 2 on down usually goes into sufficient and satisfactory evidence. And just curious why we took a different standard for item number 1 than we did the others there. Don't know that that's a problem from the legal definition, but it just seemed odd to me that we use different phrasing rather than attestation to sufficient.
Sure, 1 second. We'll
Yes.
take a
You're
I'm
recognized.
sorry, if I just found the page number. This is Francine Baca-Chavez, Deputy General Counsel with the department. Can you please rephrase your question?
Yes,
Or
ma'am.
repeat your question?
So under item number 13D1, it asks for an attestation or attestation, if you're from East Tennessee. And then in items 2 on, it asks for sufficient and satisfactory evidence. And I was just curious what the difference in the standard there is and why the difference in those. Sufficient and satisfactory evidence is kind of the rule through the rest of that part of it, and it's just different on the first one.
Yes, I have.
Page 17, Senator. 17. At the very bottom. Well, that's why I'm asking him. Because if you attest to something, it's signed, it's not sufficient evidence.
You're
Chairman,
recognized.
Representative Fritz, the applicant makes an attestation on their application, and then it's verified by the board if whether or not they do have a criminal background or not. And then the second part of that phrasing is, I'm sorry, now that I've handed over my packet, the second part of that. The second part of that is sufficient and satisfactory evidence that's verified by the board. They check their transcripts and that sort of thing to ensure that it's where it needs to be.
So the ECFMG is a standardization. The ECFMG is a standardization and qualifying body for international medical school graduates, and it functions in a way to certify that they have standardized their training for the board.
Thank you. One follow-up, please, Mr. Chairman. So just make sure I understand this. If I am this person, I attest to these things, and then from item 2 on, the process would search out the sufficient evidence. Is that correct?
Yes, sir.
Thank you so much.
Thank you. Members, any other questions? Seeing none, do we have a motion? And a second? We have a motion, we have a second. Mr. Clerk, if you would go ahead and take the roll in the Senate, please.
Senator Bowling?
Aye.
Senator Bowling votes aye. Senator Crow? Aye. Senator Crow votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Senator Rose? Aye. Senator Rose votes aye. Senator Seal? Senator Sutherland? Aye. Senator Sutherland votes aye. Chairman Jackson?
Aye.
Chairman Jackson votes aye. You have 5 ayes in the Senate.
Thank you for that. And in the House, members, all in favor indicate by saying aye. Aye. Any opposed? The ayes have it. Rule moves out with positive recommendation. Thank you all.
Thank you.
Still with the Department of Health. Item number 2. Let's see. Go ahead.
Yeah, I'll
If
go
you're
ahead and
ready,
intro-
go
yeah.
ahead and present your rule.
Sure,
please.
thank you. Again, Holt Witt, Assistant Commissioner with the Department of Health. I'm joined by Lori Lemaster, who oversees our Environmental Health Division, and Krista Kruger, who serves as General Counsel for the department. This rule packet relative to body piercing makes numerous updates and deletions as a result of our retrospective rulemaking project. The update ensures that the rule has correct citations and removes obsolete language no longer necessary to implement the statute. There were no public comments at the hearing. With that, we'd be happy to answer any questions.
Thank you for that. Members, do we have any questions? Representative Renaud, you're recognized.
Thank you, Mr. Chairman. Do I understand the rules correctly that we're moving towards allowing a young person's word that for their age that they no longer have to provide identification or bring a parent with them?
Thank you for the question. That is, the statute still requires all those things. This was deleting a duplication in the rule. So the statute still requires all the things that you mentioned.
Okay, great. Thank
Yeah.
you.
Representative Fritz, you're recognized.
Thank you, Mr. Chairman. I think this is my last question through all my review. So thank you for your patience with me. On page number 48, at the very bottom, it's got definition for decontamination. And my kind of general question is this: it's specific to biological stuff. Does this definition coordinate with in other places like radiological and chemical decontamination? And does that pose any problems for us if the definition is different in this rule than it would be in the radiological safety or chemical safety?
Representative Fritz, that's an existing definition of decontamination. It's not something that's being changed in this rule packet. Be happy to get back with you on that specific thing. The Environmental Health Division doesn't oversee separate set of rules.
Perfect.
Yep.
Thank you for that. Members, any other questions? Seeing none, is there any public comment? Seeing none, members, we're ready to vote. We have a motion for a positive recommendation. We have a second. Mr. Clerk, if you would take the roll in the Senate, please.
Senators Bowling?
Aye.
Senator Bowling votes aye. Senator Crow? Aye. Senator Crow votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Senator Rose? Aye. Senator Rose votes aye. Senator Seal? Senator Sutherland? Aye. Senator Sutherland votes aye. Chairman Jackson?
Aye.
Chairman Jackson votes aye. You have 5 ayes in the Senate.
Thank you for that. And in the House, members, all in favor, please indicate by saying aye. Any opposed? The ayes have it. Rule moves out with positive recommendation. Thank you all. Appreciate you being here. Next up, item number 3, we have the Board of Nursing. Busy man today. When you're ready.
Sure.
When your team's ready.
Thank you, Chairman. Again, Holt Witt, Assistant Commissioner for Legislative Affairs at the Department of Health. I'm joined by Mark Waters, who serves as General Counsel for the Board of Nursing, and Ms. Ennis, who serves as a board member for the Board of Nursing. This amendment adopted by the board, this amendment adopted by the Board of Nursing raises or reinstates several fees in order for the board to remain self-sufficient. In 2023, the board had a deficit of roughly $681,000. In 2024, the board had a deficit of roughly $1.7 million. The fee increase for this rule amendment are anticipated to balance the operating budget and expenses of the board moving forward. There was no public comment provided during the rulemaking hearing. With that, we'd be happy to take any questions.
Thank you for that explanation. Members, do we have any questions? Senator Rose, you're recognized.
Thank you, Mr. Chairman. How long will it take to get your fund balance where it should be, which is what, 1 to 2 times?
Thank you for the question. Because the licenses renew on a 2-year cycle, it's possible they get there in year 1, but it could also be the second year, just depending on the number of licensees that year.
And when you first start seeing those numbers dip on a downward trajectory, is there a threshold at which you decide, hey, this has gone far enough? And what is the primary cause of the funds not coming in like they once did?
Well, I don't know, Mark, if you want to,
Mark Waters, I'm the advisory attorney for the board. So I don't know that the funds weren't coming in like they once did. The board was building up a bigger and bigger carryover account. And it was decided that there needed to be a change in the rules to stop that big buildup.
Okay, I'm not sure if I got.
There was also, of course, costs continue to increase.
And that's the cost of.
But the fees coming in, I don't believe had gone down. I think costs had gone up. But
Okay.
the fees coming in had not gone down. But the board's carryover account was getting around $9 or $10 million. And so they had acted to reduce the initial licensure fees to 0. And that went on for about 6 years. So people applying for a nursing license, the first one was free. The first couple of years of licensure was free. But, there's been inflation since those times. And the board is now going to have to go ahead and increase fees in order to match what's being paid out.
Okay, thank you. Appreciate that explanation. Members, any other questions? Representative Hardaway, you're recognized, sir.
Thank you, Chairman. And I think I understood your answer to the chairman's question. You said that you got behind because the fees were flat and inflation caused the deficit.
Mark Waters. So the board about 6 years ago had reduced all the initial licensure fees to 0. So when previously somebody had been paying, let's say $100 to get an initial RN license, that fee was reduced to 0. So the first license for the first 2-year period was essentially free. And it's been about 6 years since that change was made. Since that time, there have been increased costs, and the board now has to go back and start charging fees again that were previously 0, and they're increasing some of the fees that had not been brought to 0 also in order to try to bring in approximately the same amount that's being spent.
So is there any uniform way that the health regulatory agencies are doing this, or each board just sets its own standards? We get down 2 years in a row or 30% or whatever.
The boards aim to not keep more than 2 times their annual revenue in reserves. The Board of Nursing, as Mr. Waters mentioned, had a $9 million reserve at some point. And so they looked for ways to draw that down several years ago. When boards are starting to run more than $1 million in the red each year and their reserve is getting lower and lower, the goal is to not reach the bottom of their reserve. And so that's why the Board of Nursing chose to reinstate some of the fees that they had previously removed.
So we're running a deficit, but the reserve is at,
Their current, based on last fiscal year, the reserve is at around $5 million.
and that's 2 times or less than?
The operating expenses for the last fiscal year were $9.2 million.
Okay. So I guess what I'm trying to figure out is who's helping you with these, anticipating the changes in the fees, changes for the changes in the fees. Who's helping you to project revenue? How many nurses? How many nursing licenses as a national trend? Where are you getting your data, and who's pulling this together for you? Because it would seem to me they
sure.
could do a better job.
First, the boards have a fiscal director that helps all of the licensing boards. That position is currently vacant at the department, but
You said it's vacant?
There's an interim director, but currently the fiscal director at the board is a position that's being actively filled. They oversee and help all of the boards with their financial information. So they provide projections to the boards when they're making decisions about how to increase or decrease their fees.
All right. Well, Mr. Chairman, I would suggest that it seems like having that fiscal director in place is going to help us not just with the nursing, but with some of the other boards. Thank you.
Senator Crowe, you're recognized, sir.
Thank you. You said, when you said spent, what is the money spent on? What is the need for the dollars?
Sure. I mean, a number of things, but salaries and wages, employee benefits, like all state employees, the boards are self-sufficient, so they pay their support staff. There are costs associated with investigations and contested case hearings as well. That's another larger bucket, but it goes, I mean, there are several other items that are smaller.
No, that makes sense.
Yeah.
So I guess your finance people, as GA was saying, your finance people will be making sure that the increase is proportional with not just the catch-up need or whatever, but with inflation and I guess looking at maybe what fees are in other states for the nurses. Or these are people just beginning to practice, right? Just starting to practice, I guess. Yeah.
Yes, sir.
Okay.
Members, any other questions? Seeing none, do we have any public comment? Seeing none, Mr. Clerk, you want to take a vote in the, we've got a motion and a second. Thank you, gentlemen. And go ahead and take the roll in the Senate, please.
Senator Bowling? Senator Bowling votes aye. Senator Crowe? Senator Crowe votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Senator Rose? Senator Rose votes aye. Senator Seal? Senator Sutherland? Senator Sutherland votes aye. Chairman Jackson? Chairman Jackson votes aye. Mr. Chairman, you have 5 ayes.
Thank you for that. Members in the House, all those in favor of positive recommendation indicate by saying aye. Any opposed? The ayes have it. Rule will move out with a positive recommendation. Next up, we have item number 4, mental health and substance abuse services. Guys, make yourself comfortable. When you are ready, you are recognized.
Thank you, Chairman and committee members. My name is Kristen Veloff. I'm with the Department of Mental Health and Substance Abuse Services. To my immediate right is Alex King, our Deputy Assistant Commissioner for the Division of Regulatory and Administrative Services. And to Alex's right is Dr. Wes Gimmon, the department's Chief Pharmacist and State Opioid Treatment Authority. The rules before you pertain to Chapter 940-5-35, which outlines the minimum program requirements for non-residential office-based opiate treatment facilities, commonly referred to as OBOTs.
OBOTs are primarily outpatient facilities and private medical offices that provide medication for the treatment of opioid use disorder, most often buprenorphine. Our department licenses these facilities and has since 2017, following the Tennessee General Assembly's passage of Public Chapter 912. TCA 33-2-404 requires the department to adopt rules necessary to determine the adequacy of mental health and alcohol and drug abuse prevention and treatment services. And the department has an obligation to review these for needed changes to align with best practices and trends and adjusting to the treatment landscape, along with a mandated mandate to review them each even number year outlined in TCA 33-403. After a robust review process during which the department solicited feedback from our sister agencies, including Department of Health, TBI, community stakeholders, and the Buprenorphine Treatment Guidelines Committee, the department consulted best practices materials and held a public rulemaking hearing on December 18th, 2023. The department presents these rules before you today for your consideration and a positive recommendation. With that, I'm happy to answer any questions.
Thank you for that explanation. Members, do we have any questions? Representative Renaud, you're recognized.
Thank you, Mr. Chairman. Could you very briefly tell us the difference between this rule and the next rule following, because they're so similar?
I'm going to let Dr. Gemin. Dr. Gemin, will you introduce yourself, please?
There, Wes Gemin, I'm Chief Pharmacist, State Opioid Treatment Authority for the Department of Mental Health and Substance Abuse Services. In essence, they're both outpatient facilities. OBOTs primarily prescribe medication buprenorphine, which is a Schedule III controlled substance to treat individuals' opioid use disorder, whereas OTPs primarily dispense methadone, which is a Schedule II substance, also for opioid use disorder. OTPs are more highly regulated. They're required to be certified by the federal government, have special registration through the DEA, whereas OBOT is primarily a state licensed requirement. Typically, OTPs may provide a higher level of care compared to OBOTs, just because of the frequency in which the patients have to be seen. But they are both outpatient facilities that treat opioid use disorder, but slightly different in the medications and the types of clinical services that are provided.
Any follow up? Representative Hardaway, you're recognized.
Thank you, Chairman. And I just hit the wrong button and lost my place. So I'm going from memory. Do any of these rules address the relationship between the department and, I think I heard someone reference TBI, was that correct? Yeah. But I'm not looking at that agency, but the sheriff's departments in particular, those who run the jails. Do any of these rules impact how they interact with the licensees?
Alex King, Department. I'm the Deputy Assistant Commissioner for Division and Administrative Services. Thank you for your question. So I'd say indirectly, a lot of our clinics that we license will work with jails and prisons to be able to provide the medication to incarcerated individuals, but the rules themselves are not going to specifically dictate how that relationship must exist or what the ins and outs of it.
Mr. Chairman, I'm going to ask that maybe we should look at that. Shelby County in particular is regularly running hundreds over in terms of overcrowding. Some of that, since we finally got the state to start paying for and taking some of the state prisoners back, some of that seems to be based upon how the sheriff's department, the jail, interacts with the possible beds, the possible services available. So I'm thinking maybe they could use some help, they being sheriff's departments all over the state and their jail operations. So if you would give that some thought, and Mr. Chairman, perhaps we can visit that in particular at some point. Thank you.
Representative Renaud, you're recognized.
Thank you, Mr. Chair. Are there any changes in the responsibility for disruptions that happen in the community with these types of treatment centers?
Yeah, Alex King, thank you for your question. So not any particular changes. We do have regulations that talk about how you must have a community relations plan. You must make proactive efforts to limit any kind of disruption, particularly in the rule that comes after the one we're currently talking about. We ensure that there isn't a line outside of the facility, there isn't any kind of loitering, trash is regularly picked up, that kind of thing. In the OBOT setting specifically, there's a lot less clientele coming in at one time. Those are usually scheduled visits, so there's less going on outside of the program itself, but they still have the active responsibility to have relations with any kind of local community mental health centers, outpatient substance abuse centers. If there's any kind of community effort to have town hall meetings, we encourage those to take place, and we'll participate as those happen and as we're requested, that kind of thing.
Thank you.
Members, do we have any further questions? I'd asked you, I think, in our phone conversation about how we're doing. Are we having more people that are reliant on these facilities? Are we having more people that are addicted to drugs? Are we gaining ground and we have fewer people? Could you give me like an overview the last 10 years or so, how we've trended?
Yes, sir. And I'm going to have Dr. Gammon answer that. And Chairman, I hope you got my email that I sent with those data numbers. And I'm sorry if you didn't. I will resend that and make sure I stay after to get it to you.
No worries.
Yeah, speaking in very broad generalities, we're trying to come out of the opioid crisis that we've been in for multiple years. We're trying to get more people into treatment and off of like illicit substances. We do track specific patient numbers in our opioid treatment programs, which is technically the next rule, but it has been steadily increasing since we've started tracking those numbers. Just as an example, in 2020, we had 5,800 individuals enrolled in an opioid treatment program, and the latest numbers are 9,380. A couple of different reasons for that. We've had more clinics than we did back then. And then also, TennCare didn't always cover this benefit until like middle of 2020. So with increased coverage and because people hopefully getting off of other illicit opioids and prescription drugs, getting more people into treatment, is generally considered a good thing. But of course, it's our role and responsibility to make sure that they're being provided high quality care while also being held accountable to our standards.
Okay. I also wanted to ask kind of along, you made the comment or mentioned the increased number of facilities. Are there any areas where the certificate of need issues have caused you not to be able to have adequate facilities?
Thank you for your question. So for this particular rule chapter that we're talking about, a CON is not required. For an OTP, a CON is required. That's the next chapter. As far as our involvement, the CON is a requirement on providers directly. They must obtain the CON, and that's obtained before they can even make application for a license with our department. There have been instances where providers have applied for an OTP CON and have been denied at that level, mostly based on community involvement and just general disinterest in having that in their neighborhoods. But as you mentioned, the overall number of OTPs have increased over the years.
Okay. All right. Thank you. I'm sorry. I may have jumped ahead a little bit in my notes there. Got Senator Bowling. You're recognized.
Thank you, Mr. Chairman. Thank you all for your presentation. What percentage of the people that are in opioid treatment are suffering initially receive the opioids through prescriptions?
Wes Gemmon with the department. So another difference between these two rules that we have in front of you. So with the OBOTs, which is the one that we're on currently, is primarily only done through prescriptions. So they're able to prescribe the product buprenorphine where it's filled at
I'm sorry,
pharmacies.
I must not have made clear. The people that end up in these treatment centers, their initial contact in order to go, whether it's the outpatient or whatever, did they become addicted after being prescribed these opioids?
I apologize.
Mhm.
Thank you for that question. I don't know that we track those specific numbers for these specific types of licensees. I'm sure we can get some general data survey that may estimate that, but that's not something that we track at the department.
Wouldn't that be something that would be, if you know how these people are getting into the addictions, you could better attack it at the root to try to prevent, are people regularly prescribed opioids?
Thank you.
And do we know that they're addictive?
Mhm.
Do we know they're very damaging?
Yeah.
Are there alternatives prescriptions that could be used?
There are alternative programs within the state that do analyze that data. It's just for this specific type of licensee with the rules before you, that's not part of the requirement of licensure.
Thank you.
Senator Crowe, you're recognized.
Thank you. I mean, we're talking opioids, so I just want to make sure that anybody that might have listened in online or whatever when he said we have many more clinics now, they're not talking about pill mills. Senator Briggs's bill, we probably got rid of 90 plus pill mills in this state. It was very effective. But these are our clinics where we're trying to rehab people and those sorts of things. So just want to make, in case someone out there was listening and heard the wrong thing. Yeah.
Thank you for that. Members, any other? Senator Jackson, you're recognized. Chairman.
Thank you. This just prompted a question for me, and we mentioned this a little bit the other day, but Vivitrol, are you using Vivitrol in with any of the treatments that you have?
Thank you. Wes Gammon with the department. With both of the rules that we're presenting to you today, they are permitted to use Vivitrol. Vivitrol is not a controlled substance.
Right.
It's probably not as common in these programs as some of our other programs that we might license that are not here today. And we do have several, our department offers several grant funding and making sure that it's available to the people who need it. It's just probably not the primary drug used in these two settings here.
Okay. Thank you. Thank you, Mr. Chairman.
Yes, sir. Thank you. Members, any other questions? Seeing none, do we have any public comment? Seeing none, can I get a motion? We have a motion for positive recommendation. And we have a second. Mr. Clerk, if you would, please take the vote in the Senate.
Senator Bowling. Senator Bowling votes aye. Senator Crowe. Senator Crowe votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. You have 5 ayes, Mr. Chairman.
Thank you, sir. And members in the House, all those in favor indicate by saying aye. Aye. Any opposed? The ayes have it. Rule moves out with a positive recommendation. Next up, item number 5. When you're ready, please proceed.
Thank you, Chairman and committee members. Again, Kristen Veloff with the Department of Mental Health and Substance Abuse Services. I've got Alex King, who is our Assistant Commissioner for the Division of Regulatory and Administrative Services to my right, and to Alex's right, again, it's Dr. Wes Gammon, who is our Chief Pharmacist and State Opioid Treatment Authority. The rules before you pertain to Chapter 940-5-42, which outlines the minimum program requirements for non-residential opioid treatment program facilities, commonly referred to as OTPs. OTPs are highly regulated facilities that provide medication for opioid use disorder, primarily methadone, to individuals pursuing recovery. These facilities are under strict state and federal oversight. They're required to be certified by the Substance Abuse and Mental Health Services Agency, registered by the DEA, and licensed by the Tennessee Department of Mental Health and Substance Abuse Services. TCA 33-2-404 requires the department to adopt rules necessary to determine the adequacy of mental health and alcohol and drug abuse prevention services. In fulfilling this mandate, the department has a responsibility to review these rules and make necessary changes to ensure the alignment with best practice is maintained. The department held a rulemaking hearing on December 18th, 2023, and received oral and written comments regarding those changes. Each of those comments were reviewed and responded to. The department also solicited feedback regarding these rules during an annual OTP provider meeting in September of 2024 and during routine facility inspections. Changes were made based on that feedback, and the final update to the rules are before you today. I do want to mention these changes to the rules include aligning the rules to be consistent with recent federal changes with the SAMHSA final rule. And so with that, we ask for a positive recommendation, and we'll take any questions.
Thank you for that explanation. Members, do we have any questions? Seeing none. Any public comment? Seeing none. We have a motion for positive recommendation, and we have a second. Mr. Clerk, if you would please go ahead and take the vote in the Senate.
Senator Bowling. Senator Bowling votes aye. Senator Crowe. Senator Crowe votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 5 ayes.
Thank you for that. House members, all in favor indicate by saying aye. Any opposed? Ayes have it. Rule moves out with positive recommendation. Thank you guys for being here today. Next up, we have item number 6, the Tennessee Motor Vehicle Commission. If you guys want to make your way down. When you are ready, you are recognized.
Good afternoon, Chairman and Committee. My name is Candace Dawkins, and I am the Legislative Director for the Department of Commerce and Insurance. I'm here with Denise Lawrence, who is the Executive Director for the Motor Vehicle Commission. And with us today is also Commission Chair John Roberts. These rules before you include a 50% increase for licensing fees across the board for the Motor Vehicle Commission, both on initial and renewal applications. The Motor Vehicle Commission is not currently meeting its self-sufficiency requirements with annual deficits just over $250,000 in fiscal year 2023 and nearly $790,000 in fiscal year 2024. As a result, the Commission's reserve is now below the anticipated annual expenses, which is why we are bringing this fee increase before you. The Commission has also not had a fee increase since 2010. This rule also includes expanding the authority for the Commission Chair to grant or deny a petition received for reconsideration of a final order. While the Commission currently meets quarterly, the statute governing reconsiderations requires action to be taken on a petition within 20 days, or the petition will be automatically denied. This change will allow the Commission additional time to review, consider, and vote on that reconsideration request past the current 20-day window. The rule also corrects an incorrect statutory reference on the inspections of business records. And last, this rule removes the requirement that communication from the Commission be by registered or certified mail, allowing electronic communication. These rule amendments were heard at a public hearing in March of this year and received no public comments. Happy to answer any questions.
Thank you for that explanation. Members, do we have any questions? Chairman Jackson, you're recognized.
Thank you again, Mr. Chairman. Just my question is on the fee increases. Notice that the auto auctioneers have a fee increase a little larger possibly than some of the others, and I just wanted to get an explanation on the increase there.
All of the fee increases are 50%.
Okay.
The only exception is the salesman license, which is increased from $35 to $50, but they are across the board pretty consistent with the percentages that they increased.
Okay. Thank you.
Senator Bowling, do you have a question?
No, but I do have a personal privilege that I would request. John Roberts, I would like to introduce you and welcome you here today. He is from Manchester, so that is in my district, and he chairs the Motor Vehicle Commission. And I appreciate the work that you're doing, and your family has been so instrumental in. Thank you very much, John.
All right, thank you. Or am I supposed to bang the gavel and scream out of order? I don't know. Just kidding. Members, any other questions? Representative Hardaway, you're recognized.
Thank you, Chairman, and good afternoon, ladies. Could you revisit the reconsideration rules? Is it meant to address the time element for granting the reconsideration, not making a decision on the reconsideration? Am I reading that correctly?
Yes, sir. Denise Lawrence, Executive Director for the Motor Vehicle Commission. You're absolutely correct. We want to ensure that any party that files a petition for reconsideration has a fair chance at a hearing. And because we only meet 4 times a year, if we didn't rule and say, okay, we're going to grant you consideration, and we're going to hear that on X date, the 20 days would expire. And then by default, it would automatically be denied. We didn't think that that was fair.
Okay, well, I agree. Thank you for the fairness rule. Thank you, Chairman.
Yes, sir. Thank you. Senator Bowling, you're recognized.
Mr. Chairman, another point of personal privilege. I'll take it without his allowing it. War Eagle.
Sorry. All right.
It's over.
Okay, good deal. Members, any other questions? Do we have any public comment? Seeing none. Mr. Clerk, if you would please go ahead and, oh, I'm sorry. We have a motion for a positive recommendation. Do we have a second? We have a second. Mr. Clerk, would you please take the vote in the Senate?
Senator Bowling.
Aye.
Senator Bowling votes aye. Senator Crowe. Senator Crowe votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Rose.
Rule 13, aye.
Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Back to Senator Oliver. Senator Oliver votes aye. Mr. Chairman, you have 6 ayes.
Thank you for that. Members in the House, all those in favor of positive recommendation indicate by saying aye. Any opposed? We have 1 opposition. Would you like to register that with clerk? All right, members, with that, we have a positive recommendation from both chambers. Rule moves out with positive recommendation. Next on our agenda today, item number 7, Tennessee Department of Veterans Affairs. I'm sorry, Veteran Services. When you're ready, you are recognized. You need to press the button. Yeah, thank you.
Got it. All right. Thank you, Mr. Chairman. Thank you, committee members. I'm Catherine Held. I'm serve as General Counsel for the Tennessee Department of Veteran Services. The rule before you today from us is a public records rule. The purpose is straightforward. We're looking to formalize the way that our department complies with the Tennessee Public Records Act and provide clear, consistent procedures for citizens who request access to our records. More specifically, this rule identifies the contact information for our public records request coordinator. It explains how Tennesseans may submit requests to inspect or receive copies of our records, and outlines our process for responding, including how we handle redactions and when confidential information is involved. It also describes the fees that may apply for copies. Those fees are consistent with the Office of Open Records Counsel's statewide schedule, and we waive small fees under $50 to avoid unnecessary barriers to access. The rule does not change or limit any current practices with respect to the public's right to access our records. It simply codifies the practices that we already have in place and ensures clarity for both the public and our staff. We received no public comments at the hearing, and with that, I'm happy to answer any questions that the committee may have.
Thank you for that explanation. Members, you've heard the explanation. Do I have any questions? Oh, Representative Renaud, sorry, I missed that. You're recognized.
Thank you, Mr. Chairman. Ms. Held, when we spoke, I had a question about the public chapter doesn't specifically mention the idea of folks working in concert together. And there's a rule made in here that I feel like could, I guess because it's not mentioned in legislation. Did you get clarification on that?
Yes,
On
so
whether
is
that
that,
was-
are you talking about the aggregation?
It's regarding, let's see, I don't know where it's at in the rules. I just have my notes. That records could be denied to someone who, or people who were considered to be working together to obtain records.
So that's working in concert. I'd have to go back and look in specifically which section that is. I think that's our aggregation piece where we can aggregate multiple requests. We would use that. It's used for frequent requests. We would potentially use that as a workload management tool, not to, restrict access in any way. To keep things in sort of perspective here, TDVS, I think last fiscal year received 2 public records requests. We do not maintain a very large amount of records and have never had to use any sort of restrictions on our records.
Any follow-up?
Not at this time.
Okay. Representative Hardaway, you're recognized.
Thank you, Chairman, and good afternoon, ma'am. Would you just touch on how your rules impact the ability for those who may claim indigency to be able to obtain information from the government?
Absolutely. TDVS, we are not in the business of restricting or making things more difficult for anybody. As far as potentially indigent individuals, we have specifically waived fees that are under $50, right? So we would use that to ensure that everybody has access, and could look at that on a case-by-case basis. Of course, we don't really anticipate that any of our records requests would exceed that amount, but we are able to waive fees under certain circumstances.
Okay, and this is about veterans. So is there a special category consideration rather for veterans who are seeking information?
Not in this rule. This rule is consistent really with the statewide, most other records rules. So there's nothing in here specifically that would waive a fee for a veteran solely for being a veteran when they request access to records.
So would you need legislation through the chairman or one of the other members before you could bring that rule?
If you all decide to bring something along those lines, we could look at that time.
Thank you, Mr. Chairman. I'd like to co-sponsor that with you.
Thank you. Thank you for giving me a bill to run. Appreciate that. Members, any other questions? Seeing none. Any public comment? Seeing none. And I'm looking for my second down there, Senator. We've got a motion. We've got a second. Mr. Clerk, please take the vote in the Senate.
Senator Bowling. Senator Bowling votes aye. Senator Crow. Senator Crow votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Oliver votes aye. Senator Rose. Aye. Senator Rose votes aye. Senator Seal. Senator Sutherland. Aye. Senator Sutherland votes aye. Chairman Jackson. Aye. Chairman Jackson votes aye. You have 6 ayes, Mr. Chairman.
Thank you for that. Members to the House. All those in favor indicate by saying aye. Aye. Any opposed? The ayes have it. Rule moves out with positive recommendation. Thank you. Next up, item number 8, the Department of Commerce and Insurance, Tennessee Collection Services Board. If you guys make your way forward. When you are ready, you are recognized.
Hello again. Thank you, Chairman and Committee. My name is Candace Dawkins, and I am the Legislative Director for the Department of Commerce and Insurance. I'm here today with Roxana Gamusio, who is the Executive Director for the Collection Services Board. The rules before you are a result of the department's retrospective rule review. These rules reorganize the list of prohibited practices to be within the rule governing standards of practice. The rules also clarify the definition of change of ownership for corporations and LLCs. The rules on examinations are repealed as they are not required and there is no substance within the rule. These rules also remove the requirement that the board contact an applicant's character references as a part of the licensure process. Lastly, the rules include that a violation of the Fair Debt Collection Practices Act is deemed a deceptive act or practice in violation of the board's rules. These rules amendments were heard at a rulemaking hearing in January of this year and received no public comments. Happy to answer any questions.
Thank you for that explanation. Members, do we have any questions? Seeing none, do we have any public comment? Seeing none. Mr. Clerk, would you please go ahead? Oh, sorry. We have a motion for a positive recommendation. Do I have a second? And we have a second. Mr. Clerk, would you please take the vote in the Senate?
Senator Bowling,
Aye.
Senator Bowling votes aye. Senator Crow, Senator Crow votes aye. Senator Hatcher, Senator Kyle, Senator Oliver. Senator Oliver votes aye. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 6 ayes.
Thank you for that. And members to the House, all those in favor of positive recommendation, please indicate by saying aye. Any opposed? Ayes have it. Your rule moves out with positive recommendation. Thank you guys for being here. Next up, we're on to item number 8, Department of Commerce and Insurance. I'm sorry. I think we just finished that. Time to change the page. Next up is the Tennessee Real Estate Commission. Whenever you're ready, please go ahead and introduce yourself again for the record and let us know about the rule.
Hello again. I'm still Candace Dawkins, Legislative Director at the Department of Commerce and Insurance. I'm now joined by Denise Baker, who is the Executive Director of the Tennessee Real Estate Commission. These rules are also a part of the department's retrospective rule review. In light of the Fresh Start Act, these rules remove a mandatory 2-year waiting period after the conclusion of incarceration, parole, or probation for applicants with a criminal conviction before applying for licensure. Statute and rule will maintain protections for the public against those with convictions of theft, forgery, fraud, embezzlement, or other convictions. These rules also include details on what information is required to be included on errors and omissions insurance policies. These policies are already required for licensees. The rules simplify the civil penalty schedule for violations of statutes, rules or orders of the commission. They clarify which applicants are required to appear before the commission and amend the gifts and prize rules to include gift cards. The commission received 1 public comment on the use of gift cards ahead of the hearing and amended that portion of the rule in response to include limited usage for gift cards. Lastly, these rules repeal requirements for telephone answering services and the interpleader form. The rule amendments were heard at a rulemaking hearing in December of 2024, and outside of that 1 comment, no other public comments were received. Happy to answer any questions.
Thank you for that explanation. Members, do we have any questions? Seeing none. Any public comment? Seeing none. We have a motion for a positive recommendation. We have a second. Mr. Clerk, would you please take the vote in the Senate?
Senator Bowling,
Aye.
Senator Bowling votes aye. Senator Crow, Senator Crow votes aye. Senator Hatcher, Senator Kyle, Senator Oliver. Senator Oliver votes aye. Senator Rose, Senator Rose votes aye. Senator Seal, Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 6 ayes.
Thank you for that. Members to the House, all those in favor of positive recommendation, please indicate by saying aye. Any opposed? Ayes have it. Rule moves out with positive recommendation. Thank you for being here. Now we're on to the Tennessee Athletic Commission, item number 10 on your agenda today. When you are ready, you are recognized.
I believe this is our last one, so you'll be done with me after this one. Again,
Too fast. Went by too fast.
Candace Dawkins, Legislative Director at the Department of Commerce and Insurance. With me again is Roxana Gamuccio, who also serves as the Director of the Tennessee Athletic Commission. The commission regulates unarmed combat sports such as boxing, as well as mixed martial arts, kickboxing, and Muay Thai. The rules better align Tennessee to the Association of Boxing Commission's uniform rules for those regulated sports while still allowing the commission the option to approve alternative Tennessee-specific rules. Aligning the uniform rules will help fighters, promoters, and ring officials operating in multiple states to better understand the rules for these contests. Additionally, the rules ensure that event promoters are responsible for hiring ring officials who are aware of the event or contest rules and emergency procedures of the venues. This rule was heard at a public rulemaking hearing in March of 2025 and received no public comments. Happy to answer any questions.
Thank you for that explanation. Members, do we have any questions for the presenters? Seeing none. Do we have any public comment? Seeing none. We have a motion for positive recommendation. We have a second. Mr. Clerk, second was by Senator Bowling. And if you would please take the vote in the Senate when you're ready.
Senator Bowling.
Aye.
Senator Bowling votes aye. Senator Crow. Senator Crow votes aye. Senator Hatcher, Senator Kyle, Senator Oliver. Senator Oliver votes aye. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 6 ayes.
Thank you. And members to the House, all those in favor indicate by saying aye. Any opposed? And the ayes have it. The rule moves out with a positive recommendation. Thank you, ladies. Next up, item number 11 on our agenda today, we have the Department of Human Services. When you are ready, please go ahead and begin.
Good afternoon, Chairman and members. I'm Callan Baggett, Assistant Commissioner with the Department of Human Services. I've got Paige Foster and Becca Parkhurst with me as well from our team. We have some rules in front of you that are updating our rules that govern our Appeals and Hearings Division. As you all know, the Department of Human Services administers a number of federal programs, and every one of our customers, your constituents, has the right to appeal any of our decisions. And so the rules in front of you actually came out of the retrospective rule review. That was a piece of legislation that was passed by the General Assembly. And so this is cleaning up a number of definitions, rules. For example, SNAP is referred to as food stamps in our rules, and that has not been in place federally for a good amount of time. TennCare has transitioned away from DHS years ago, but their appeals were still in our code. So we are placing the rules in the right places throughout the code. And additionally, we are finding some efficiencies within our rules that we are updating. For example, switching mail vendors for our appeals notices. With that, I'll be happy to take any questions.
Thank you for that explanation. Members, do we have any questions? Representative Clemens, you're recognized, sir.
Thank you, Mr. Chairman. I'm curious about this provision here. In your summary, it says that you're updating provisions regarding representation to comply with the Attorney General's opinion. The Attorney General's opinions are simply one attorney's opinions. They don't have any binding impact, and they're not the rule of law. So I'm curious as to what the representation provision was amended, and whether it's in compliance with the law that we passed, or if it's simply in compliance with the Attorney General's opinion that has no binding impact.
I'm going to turn that over to Becca Parkhurst, our Deputy General Counsel.
Yes, Rebecca Parkhurst, Deputy General Counsel. We amended provisions regarding representations in those administrative hearings. It wasn't clear in our rules that if you're a corporation, you have to be represented by an attorney in those administrative hearings. That is in an Attorney General opinion, but it also, is in the rules of representation that you do have to have an attorney represent you as a corporation. And so the rules made that amendment to make that clear. You can, of course, represent yourself if you are not a corporation or a registered company.
Do you have a follow-up?
And so it's the department's opinion that that's in line with and compliance with the spirit of the law that was passed?
That is correct.
Okay, thank you.
Yes.
Thank you for that. Any other questions? Representative Hardaway, you're recognized.
Thank you, Chairman. Once again, in the summary, it makes reference in the fiscal impact of a savings of $250,000.
Yes, sir.
Would you expound on that, please?
So every single appeal, the customer must receive a written notice of the date of their appeals hearing. We had previously used one vendor that charged more, and we are switching to U.S. Postal Service, which charges less.
And I'm going to resist. Thank you, Mr. Chairman.
Thank you.
Post office has enough problems without me.
Members, any other questions? Seeing none, any public comment? Seeing none. We have a motion for a positive recommendation. We have a second from Senator Bowling. Mr. Clerk, when you're ready, would you please take the roll call in the Senate?
Senator Bowling. Senator Bowling votes aye. Senator Crowe. Senator Crowe votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Oliver votes aye. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Senator Sutherland votes aye. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 6 ayes.
Thank you for that. Members to the House, all those in favor indicate by saying aye. Any opposed? Ayes have it. The rule moves out with a positive recommendation. Next up in our agenda today, item number 12, State Board of Education. Their rule on the mission of the State Board. When you're ready, sir, proceed.
Thank you, sir. I'm Nathan James with the State Board of Education, and I'm joined by our intrepid General Counsel, Rachel Supay. Our first one, this is on page 424 of your rule packet. This is preface rule repeal for 0520-01-01. This item repeals State Board of Education Rule Chapter 05200101 preface, as such rules are outdated and unnecessary. Specifically, Rule Chapter 05200101 merely restates requirements set forth in state law and the state constitution, as well as the board's mission, which can be found in the board's master plan, which is developed and revised every 3 years pursuant to TCA 49-13302A3. These rules have not been updated since 1984 and 1986, respectively. They were identified for repeal as part of the required 8-year rule review report required by TCA 45213. This law required all state departments and boards to submit a report to the chairs of the Government Operations Committee of both houses of the General Assembly, identifying rules that could be amended or repealed, needed further review, or could go into effect. And this repeal supports the governor's and the General Assembly's goal of reducing unnecessary state regulation. With that, I'm happy to take questions.
Thank you for that explanation. Representative Renaud, you're recognized.
Thank you, Mr. Chairman. When I read these rules, I took it that it wasn't really a rule that was being repealed, but the mission statement of the Board of Education. Is that correct?
Right. But at the time that it was done back in 1984, 85 timeframe, the state board had been reconstituted for its most recent occasion, and since it's existed since 1814 and 1836 respectively. So it appeared in rule, it had to be repealed as a rule.
You're recognized.
And so I understand that mission is now placed in the board's master plan.
Yes, ma'am.
And is that word for word that it just transferred over?
Oh, no, it's the master plan is far more in depth. This is just a piece of rule that was passed way back when and needed to come out, and the law you all passed 45213 made sure that we were looking at that, and so that's why it's repealed here.
Any follow-up?
I'll just make a comment. I just find it interesting that the mission statement would be considered a rule and why that would be repealed. And because obviously that is a guiding statement for what you guys do. So I'll just leave the comment there.
So our master plan is on our website, and it's 18 pages long. So there's just a lot more to the master plan than the one overarching statement. But I totally understand it's anomalous to see something like that in rule.
Thank you for that. Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. My concerns echo that of my colleague from Hamilton County. The mission statement simply says the mission of the State Board of Education is to ensure that Tennessee schools are among the best in the nation. What has changed? And why would we eliminate that statement from the rules?
Well, it appears several other places. And one of the things that this committee has been pretty clear about is that if something is redundant or is taken care of elsewhere in law or some other place where it's required, that you try to clean up the regulations and rules where possible. So we thought we were doing what the law would require us to do.
Follow up?
Yeah, I mean, it seems to me that it's a statement that we could not repeat enough to remind us of what our job and duty is here with regards to Tennessee's schools. So I find it odd that the State Board of Education has taken it upon itself to interpret the law to eliminate a simple mission statement that sends a clear signal where we stand as a state. And then again, you repealed the responsibility provisions stated there in subsection 1 with regards to the state's responsibility with regard to education. States, it says the responsibility for the support and control of public education in the United States has been recognized as a belonging to the respective states. We talk a lot about states' rights and state role over issues up here. And that simply restates that, which I think we all feel pretty strongly about. And this state's duty with regard to public education. So I'm curious why that would be repealed.
Rachel Supay, General Counsel for the State Board of Education. Our rules are meant to be instructive to our school districts. They're meant to provide guidance to our staff and teachers in schools. They're meant to outline the processes for students to receive the best education that they possibly can. And they're meant, our rules, to have teeth to them. Whereas a mission statement that's more aspirational but doesn't necessarily lay out any legal requirements, if anything, would be more appropriate for a policy than a rule. But to Mr. James' point, we have the mission statement on our website, in our master plan. It is located in multiple places, but it's not appropriate to have aspirational statements necessarily in rule. It doesn't impact the rights or privileges of a third party.
Thank you, Mr. Chairman. Yeah, I find that really concerning that if the local governments and these LEAs and across the state are looking to the state for leadership, and the very purpose for the rules, that they wouldn't begin with aspirational statements to give them hope and trust in the state government that we're going to be here to support them and that our mission is to ensure that Tennessee schools are among the best in the nation. If I was an administrator in an LEA, that'd be the first thing that I wanted to see when I look at the rules telling me how to do my job.
I will say much of this is in our authorizing statute. So this was also an effort to reduce any duplication between the law and our rules.
Thank you, Mr. Chairman.
Representative Parkinson. Hit your button down there, sir.
Okay, sorry about that. And thank you for being here. You said that the mission statement is in your authorizing statute. Is it implicit just as it is here in the authorizing statute? And can you tell us where that is?
Let me clarify.
Okay.
The authorizing statute lays out the responsibilities of the State Board of Education, and Representative Clemens had been referring to our state board's responsibility. So my purpose was to clarify that that is still in statute.
Representative.
So, thank you. So the portions that I'm looking at, number 1, 2, 3, 4, and 5, you're saying they're in statute?
I can double check, the particular sections, but
Okay.
I want to be clear that this was meant to be a cleanup and a clerical edit and not a substantive one. Taking this preface out doesn't in any way, change the state board's work or priorities.
And so here's my concern. If we're removing this and we can't point, directly to where this exists in other areas of our code, then if there was a need or a want to change this language, then you wouldn't even have to come before this body to change it. Am I incorrect in that assessment, or am I correct in that assessment?
I would say this. I mean, these statements are also laid out in our master plan, which is pursuant to law. I understand what you're getting at. And I'd also offer to you and any member here, if it would be of help, to come by the office and we could spend some time going through the master plan and what's in there. We'd love to certainly have each of you involved.
And last one, Mr. Chair, I appreciate that, and I appreciate what's in the master plan. But I'm more concerned about what's in statute and what is not, and remove. I mean, you look at this. The responsibility for the support and control of public education in the United States has been recognized as belonging to the respective states, and it. To remove that, and especially in the absence of being able to know or see where this is implicitly spelled out in other areas or, places in the code, it gives me grave concern, seriously. Okay, thank you, Mr. Chair.
Thank you for those comments. And members, keep in mind through the rule-making authority that the departments agencies have at the same time, we put pressure on them bringing legislation to force them to change things. And that's why we're here and meet monthly to go through those rulemaking and of course, when we pass legislation for correcting such as what we are doing today. Any further questions for Representative Hardaway?
Thank you, Mr. Chairman. And thank you for your explanation that kind of raises more questions in my mind than it settles. Because my understanding of our role is to make sure that legislative intent is carried out. So what's in code is represented accurately in the rules. And I've been here since 2007. Maybe that has changed, maybe it has not. But with that in mind, if the master plan is where we'll find the mission statement, will the master plan come before the Government Operations Committee?
Mr. Chairman, no, the master plan does not come before the Government Operations Committee. Where the master plan is dealt with is in the public meetings of the State Board of Education, which each and every one of you are always invited to. We have, our members can't even have a conversation really with one another except on the record. So we do every bit of it in complete transparency. And I'm happy to be of whatever help I can be to facilitate if you'd like to come and be part of that. It's certainly something that we spent a great deal of time on, because 49.1302 is the portion of the law that lays out the role of the State Board of Education and its responsibilities, and they are quite expansive. So with the master plan process, we go through what the law requires us to. And we try to set those aspirational goals for the people of Tennessee, because we're all wanting to be rowing in that same direction, as I know you
Representative
do.
Hardaway, further question?
Yeah, and I appreciate the answer. It didn't address my question, though, and that's whether we are taking away from the authority of government operations the ability to approve the mission statement.
I have the statute pulled up regarding the master plan. If you'd like, I'm happy to read it, but it directs the state board to develop and maintain a master plan for the development of public education. I'm paraphrasing here, and provide recommendations to the executive branch, the General Assembly, and local boards of education and directors of schools regarding the use of public funds for education. So it does direct the board to adopt that master plan and doesn't require that it come before this committee.
All right, so Mr. Chairman, with that in mind, I'm going to have a problem supporting this rule. I think that the committee should have some say-so into how that mission statement reads. I don't want to wake up and read the newspaper and see that y'all have done something that I was unaware of and had no input in. So I'm going to vote no on these rules. Thank you.
Next on our list, Chairman Jackson.
Thank you, Mr. Chairman. And I'd just like to know, are there other departments or agencies that have their mission statement in the rules that you know of?
I couldn't speak to that. I just know that this was something that's been in there since 1986, and hasn't been changed. And when you all passed a law saying you need to review absolutely everything you've got in rules and see if it's redundant, and if so, bring it up. That's what we were operating under.
Chairman
Thank you.
Jackson.
Thank you, Mr. Chairman.
Thank you. Any further questions, comments? Representative Bruno, please.
Thank you, Mr. Chairman. So to reduce redundancy, or do you interpret that to reduce redundancy in the rules, or just in all the other documents that you guys deal with, like, for example, the master plan? And does the legislation specify that?
So let's see, we'll have to pull up 45213. And it's 45213. This is about the required eight-year rule review report required.
The statute doesn't use the word redundancy explicitly, and it's a little bit long, but I'm happy to read the relevant portion. My understanding, though, is that it's meant to reduce duplication between statute and rule, which is what we've tried to do here by eliminating the language from rule, since 491302 talks about all of the state board's duties under the law. So we felt for that reason it was duplicative.
Representative Bruno.
So this mission statement is the only place that it's found in the master plan now, after it will be repealed from the rules?
I can check. I imagine, it might be restated in a number of our documents, but I'm happy to check on that and then send any that I'm able to identify your way, if that would be helpful.
Thank you.
Any further questions, comments? Seeing none. Any public comment? Seeing none. Ready to take a motion at this time? Motion approved. We've got a motion and a second. Clerk, please take the vote in the Senate.
Senators Bowling?
Aye.
Senator Bowling votes aye. Senator Crow? Senator Crow votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Senator Oliver votes no. Senator Rose? Senator Rose votes aye. Senator Seal? Senator Sutherland? Senator Sutherland votes aye. Chairman Jackson? Chairman Jackson votes aye. Mr. Chairman, you have 5 ayes and 1 no.
Thank you, sir. In the House, voice vote, all in favor, state by saying aye. And any opposition, nay? Nay. Raise your hand so the clerk can record you. Moves out with positive recommendation. Chairman Lafferty.
Thank you for that, Chairman Reedy. Appreciate your help. Next up, item number 13, still with the State Board.
Thank you, sir. Nathan James with the State Board of Education, again, joined by Rachel Supay. We're on page 435 of your rule packet. This is the textbook and instructional materials waiver rule 0520-01-18-.01 through .03. TCA 491302A9 charges the board to prescribe the use of textbooks and other instructional materials based on recommendations of the State Textbook and Instructional Materials Quality Commission by approving statewide subject-based textbook adoption lists from which districts may choose. TCA 49-62206 authorizes the state board to approve or deny waiver requests from local education agencies that wish to use textbooks and instructional materials that are not approved if the LEA demonstrates unique or unusual needs. The state board's textbook and instructional materials waiver rule governs the process and procedures for LEAs requesting textbook and instructional material waivers from the board. Revisions to the rule include clarifying the process for LEAs if there are no approved textbook and instructional materials for a given course or grade level based on LEA and TDOE feedback. Two, it provides the option for LEAs to submit to the SBE research or evaluation on the proposed textbook and instructional materials to support a high-quality adoption, and it made clarifying and technical edits to support transparency and effective implementation. The board held a rulemaking hearing on the 2nd of May, 2025, between the first and final readings to collect feedback, and no public comments were received. We remember that the state of Tennessee has adopted very specific state standards, and there are a number of statutes that have been passed that make it clear that the textbooks and instructional materials adopted must adhere to those Tennessee state standards.
Thank you for that explanation. Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. I just want to get clarity here. So these rules are intended to reflect the concerns by this body about prohibited divisive concepts. Is that correct?
These rules are about instructional material waivers. That is to say, if you're a school district, you've got the list of approved textbooks on a particular subject, and you wish to use a different one. Or perhaps in the case that there simply weren't enough. There weren't enough options, and no textbook was approved for a particular subject. This is about that.
Yeah. So I'm just trying to get clarity here. I mean, the spirit of the law, I mean, with this state, and it even references prohibited concepts in here on page 444 with regards to that waiver you're discussing. So I just want to make sure. I mean, this is carrying out this body's position that we don't want public dollars being spent to teach prohibited concepts. Is that correct? Is that your understanding?
The law prohibits the use of any textbook or instructional materials that include or promote those topics. And at the state board, we're not allowed to, of course, have any flexibility there since it's in statute. So what our rule just says is that an LEA has to provide an assurance that any textbook and instructional materials that they want to use complies with Tennessee law and any applicable federal law. And so that would include the law you're referencing, but it would include any other state laws about the requirements for instructional materials.
Okay, thank you.
Members, any other questions? Representative Hardaway, you're recognized.
Thank you, Chairman. And good afternoon again. How do these rules impact charter schools?
Just like a school district, a charter school is allowed to request a waiver to use materials that are not on the state-approved list.
So charter schools will have to bring everything to the state board before they can experiment, before they can use materials that may work out better than what the board has approved?
If they would like to request a waiver to use materials that are not approved by the state, they have a few options. Number one, they could request that waiver from their authorizer, which is usually the school district, but it might be the Tennessee Public Charter Commission, or they can request, a waiver from the state. And that is the same rule that applies to any, school district that also wants to apply for a waiver to use unapproved materials. It's the same process, other than that the LEA has to go to the state rather than their authorizer.
All right, and I asked because I saw one of my favorite former superintendents, Dr. Carol Johnson, and she was famous for recognizing charters as being an experimental environment that would develop best practices and allow for that experimentation to happen. But we'll follow up on it later. Thank you.
Members, any other questions? Seeing none. Any public comment? Seeing none. We have a motion for a positive recommendation and a second. Mr. Clerk, when you're ready, please take the vote in the Senate.
Senators Bowling. Senator Bowling votes aye. Senator Crow. Senator Crow votes aye. Senator Hatcher. Senator Kyle. Senator Oliver. Senator Oliver votes no. Senator Rose. Senator Rose votes aye. Senator Seal. Senator Sutherland. Chairman Jackson. Chairman Jackson votes aye. Mr. Chairman, you have 4 ayes and 1 no.
Thank you for that. And members to the House, all those in favor of positive recommendation indicate by saying aye.
Aye.
Any opposed?
No.
Okay, we, in this instance, have no recommendation from the Senate, and we do have a positive recommendation from the House. Thank you. Next up, item 14, still with the State Board. When you're ready, you're recognized.
Thank you, Mr. Chairman. I'm Nathan James with the State Board of Education, still joined by Rachel Supay, and we've got also some of our folks here from the State Department of Education on my left. Let them introduce themselves.
Thank you all for your patience. It takes me just a minute to get up here.
No worries.
Emily Cornute, Director of Legislative Affairs, Tennessee Department of Education.
Good afternoon, everyone. I'm Trudy Hughes. I serve as the Assistant Commissioner of Choice for the Tennessee Department of Education.
So we are on page 449 of the rule packet. These are Education Freedom Scholarship Rules 0520-0124. On the 12th of February, 2025, Governor Bill Lee signed into law the Tennessee Education Freedom Scholarship Act. That was Chapter 7 of the Public Acts of 25, first extraordinary session. PC 7 creates the Education Freedom Scholarship Program and authorizes the State Board of Education to promulgate rules to effectuate the EFS program. EFS is a school choice program that allows Tennessee students who attend Category 1, 2, or 3 private schools to access state scholarship funds to apply toward educational expenses. PC 7 states that private schools that enroll EFS recipients retain their autonomy. Further, it clarifies that the EFS program does not expand the regulatory authority of this state beyond, quote, the rules narrowly tailored to enforce the requirements of this program, end of quote. As such, the proposed rules focus on defining key terms, establishing application and eligibility processes, establishing appeals procedures, and setting forth other logistical matters necessary to effectuate the program. It's rare to have a statute that sets out very, very clearly what the instructions are in the rulemaking process the way this statute did. The State Board of Education staff held a rulemaking hearing on 12 May 2025 to solicit public input on this rule before its final reading. The board received 28 public comments on the rule, which were shared with our board members for their review. The comments were regarding the legislation and did not propose revisions to the rule, or they proposed revisions to the rule that were specifically in conflict with the legislation. Therefore, the State Board of Education did not revise the rule in response to those public comments due to those direct conflicts. With that, we're happy to take questions.
Thank you for that explanation. Members, do we have any? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. So I think we've established today that you're not tied only to what the law says, but you have the ability to interpret it, and that the purpose of these rules is to administer and implement the law in a manner reflecting the purpose and intent of the law, and provide clarity to those so you can comply with it. So when we passed this bill, the governor of Tennessee traveled all over the state of Tennessee representing that this law would provide opportunity to children that wouldn't otherwise have it, meaning children who weren't already in private school would be able to attend private school potentially. Yet I see no rule in here in furtherance of the spirit of the law or the representations of the governor telling us or providing us with data that shows how many children accepting these vouchers would be in private school already. Why is that?
The section of the code that was instructive to the rulemaking process here specifically was, quote, "The rules narrowly tailored to enforce the requirements of this program," end of quote. And there were certainly conversations. People have different ways of looking at things, and I understand all of that. However, it's pretty rare for us as the State Board of Education in a statute that passes, and as you know, because we see each other a great deal here, there are a great many changes in education law most years. But this statute ordered the State Board of Education to create only those rules necessary to enforce the requirements of the program.
You recognize, sir.
Thank you, Mr. Chair. So narrowly tailored. I mean, I think it's your job to narrowly tailor every law with rules. I don't think anybody wants unelected officials, or I mean, there are a lot of complaints about, legislating outside of this building here and in DC. So that applies to every law. Yet again, we've established here today that you have the ability to interpret this and carry out the spirit of the bill. And the governor made these representations all over the state that this was going to provide opportunity. This was going to provide choice to those who didn't have it. Yet we have no way, and these rules don't even direct the department to collect the data telling us how many children were already in private school that are accepting these vouchers. Now, I find that incredibly hard to accept, given that it was a main concern and was discussed numerous times in committee and on the House floor with regards to legislative intent. There was no secret about this or those concerns. So again, why haven't we even directed the department to collect that data in these rules, as you have in other rules we've looked at here today?
My understanding is that there was discussion when the bill was working its way through the legislature about whether or not to include a requirement in the legislation to direct the department to collect that information. And that was left out intentionally from the bill. So our interpretation is in line with the spirit in that sense and the wording of the law.
One more, please.
Well, Mr. Chairman, I have three more topics, and I'll be very brief with all of them. One is with regard to the physical location, the definition of private school in this rule, and the vagueness associated with it. Another concern that was raised was that virtual schools are going to be able to receive these vouchers. And my reading of this definition of a private school, they simply have to own or lease property in the state where students may receive educational services and testing. That doesn't mean that they can attend classes there. We have no definition of educational services or testing in this rule. I mean, you could be describing an SAT prep class with that definition. So my concern is the vagueness and ambiguity with regard to that, because yet another concern of everybody on both sides of the aisle was who could receive these vouchers and be a participating school.
I'm happy to speak to that. The definition of a private school in the rule it includes two requirements. So having a physical location is only part of the first part of the requirement. It also needs to be a category 1, 2, or 3 school, which is defined in our non-public rule. So when you look at those together, it wouldn't allow for an ACT, prep program wouldn't meet this definition because it's not a category 1, 2, or 3 approved school.
What about a virtual school?
If they are a 1, 2, or 3 school that has a physical location in the state where students are able to come and receive testing or services, if they meet that definition, I can't say whether or not they would meet that definition.
Okay, well, we have a real problem there with the ambiguity because educational services are not defined, so we don't know what that looks like. And that is a serious concern. Next, with regards to, there's a reference in here. Let me find it here. Page 468, use of funds. Explicitly talks about, and the first thing you can use use of funds for, and these are, again, public dollars, state funds, textbooks, curricula, instructional materials. I didn't see anywhere in the rules limiting what textbooks, curricula, instructional materials that these private schools can use. Why is that?
That would be up to the private school to determine.
Well, see, we just had the rule before, and I asked you about that. That the purpose, that the concern of this body was that public dollars wouldn't be used to teach prohibited concepts or divisive concepts, as that term's been used. Yet here we are adopting a rule or proposing a rule that allows any private institution to use any textbook, curricula, instructional material that it wants with public dollars.
The instructions in this law were to create rules narrowly tailored to enforce the requirements of the program. And so to broaden restrictions on private schools that don't elsewhere exist in statute were considered to be in violation of those clear instructions delineated in the public chapter.
Well, I appreciate that, but I think we've pretty much set, it out here today and shown that this state and this body has sincere concerns about what's being taught in schools with public dollars. And so I find it odd that the same wouldn't apply to this program that's being funded with private dollars or with public dollars. So the hypocrisy there is shocking to me on multiple levels. The next question I have is with regards to the funds disbursement on page 468. This was something else that was raised. And again, this is one of those examples where you instruct the department to do something. And I based on what you've said, I assume this was in the statute that you should establish procedures to effectuate the EFS funds transfer process. And we've had concerns about the money going back and forth and whether or not a child dropped out of the private school or got kicked out of the private school and sent back and how those funds would be transferred. Does this provision concern paying that private school the funds for that child, or does it also cover how the funds will get back to the state of Tennessee or the fund?
I believe the statute, Public Chapter 7, spells out what is to be done with any excessive funds as a result of a situation like that, but I will certainly defer to my colleagues at the department if they would like to add on about the process for remitting any of those funds.
Emily Cornute, Tennessee Department of Education. I'm going to defer to Trudy Hughes.
Trudy Hughes, Assistant Commissioner. Regarding funds that are actually awarded to families to use for students that are benefiting from the Education Freedom Scholarship, if a student withdraws from a non-public school, registered EFS non-public school, those funds revert back to the department. So if a child chooses to withdraw, which can be done by the parent or the school can let us know that child has withdrawn, those funds come back to the department.
Does the department have rules and a process that governs that at this moment, or are you awaiting the passage of these rules directing you to do that?
There is guidance within the department that shows how those funds are received, and granted, they will go back to the Finance and Administration Committee and be appropriated according to what the rule itself and law states.
I will clarify to answer your initial question. The rule does require and state explicitly that upon the termination of a recipient's participation in the program, the department shall close the recipient's EFS account and any remaining funds shall be returned to the state.
That's all I have for now, Mr. Chairman. Thank you. I appreciate it.
Yes, sir. Next up, we have Senator Oliver.
Thank you, Chairman. A few questions here. One is around the public comments that you received. I noticed that a couple of them were in regards to the timing of awards that are given for these scholarships. And the public comments seems to be coming from either a private school administrator or possibly a private school parent. And it's around the incongruency of when the state awards these scholarships and when these private schools actually make their decisions. So right now, as it states in one of the comments, is that the admission cycle of independent schools begins in the fall, and their deadline to apply for tuition assistance is December 15th. that is well before our fiscal year, which is June, July, when that rolls over. So it seems to me that if I'm interpreting this correctly, that a parent that wants to apply for this scholarship program in future years, they're going to miss out because those private schools have already made their academic decisions for the year. So any public school parent that might want to enter that private school, it's too late. So by design, it appears that once again, it has been stated here before, that this program is by design for parents that are already in private schools. Would you care to comment or dispute that interpretation?
I'm happy to comment on your initial question about the public comment. That public comment in particular, as stated in Mr. James' talking points, did not propose or request any changes to the rules specifically. That said, I know the department is working to ensure that the timeline for processing applications is in line with, to the best of their ability, the schedules of the schools and what's most convenient for families. That said, my understanding is because of the timing of the legislation this first year, the application cycle was a little bit different this year, given when the law was signed, than how it will roll out in future years. But certainly, I will call on my colleagues at the department if they would like to add anything about the timeline.
The department has no additional comment.
Okay. So again, my second question is around conditionally approved applications. It appears and it states that the definition of that, a parent has to have proof of enrollment in a private school in order to be conditionally approved. And that is one of the categories of an application. So if a person is already conditionally approved, then that means they've already been admitted to a private school. Again, how does a public school parent get into this education scholarship program if the conditionally approved applications take priority because they're already in a private school? And I'm looking on page 462, if you're curious.
I hope I'm getting at your question. My understanding of the conditionally approved is meant to address a situation in which there was a waiting list. If there were more students applying than we had scholarships, if you are conditionally approved, you're on that wait list. And should a spot become available, you would then switch from conditionally approved to fully approved.
Okay. Last question is around, let me find it here. I think it was page 472 under return to public school. If you could clarify item number 4 under that section. In the last sentence, this is dealing with students with a disability. A recipient in the program is not entitled to receive a FAPE through an IEP, but he or she is eligible to receive equitable services. So does this mean that if a child is returning to a public school, they won't receive the same IEP that they received when they left, and then they will get substandard in equitable services?
That's a great question. If a student with a disability returns to public school, they would likely undergo an evaluation by the public school district at that time for special education services. And then if they're determined to still need special education services, the IEP team, assuming the parents consent to the provision of the services, would then draft that IEP. If the student has only been out of the public school system for perhaps a month, it might look identical to its previous IEP. But if a student, let's say, was at a private school for 5 years and then returned to public school, it wouldn't be appropriate to have the same identical IEP that was in place 5 years ago. But if the student is still eligible, the IEP team would be required under state and federal law to draft a new IEP at that point in time.
Thank you.
Thank you. Representative Parkinson, you're recognized.
Thank you, Mr. Chair. You mentioned the rules being narrowly tailored. Was it for the administration of the program? How did you phrase that? I don't.
Yeah, Mr. Chairman and members, the statute states, quote, "The rules narrowly tailored to enforce the requirements of the program," end of quote.
Yeah, thank you for that. In regards to the requirements of the program in statute, was it not set out to require a certain percentage of the awardees to fit a certain criteria in order to be awarded a voucher? And what did the code set out in regards to those percentages? And I think based on the income requirements, if I'm not mistaken.
Thank you for that question. Trudy Hughes, Assistant Commissioner for the Department of Education. For the first year, there were 10,000 scholarships that were set aside, and they were qualified scholarships based on an individual family actually providing information that they feel their annual household does not exceed 300% of the amount required for a student to qualify for free or reduced price lunch. Another way they could prove this income verification was through the Tennessee Assistance to Needy Families and SNAP. And also if a student was eligible for the ESA program or the IEA program, then they were eligible for one of the 10,000 that were reserved for the qualified scholarships.
And were there not? Is that the only requirement? Because I thought it was tiered. Am I mistaken in how that?
I think what's reflected in the law is actually next year's prioritization of the awards for 26, 27, and the years moving forward. There are tiered awards and prioritization at that level, but this year there were 10,000 that were universal scholarships, and then there were 10,000 that were reserved for those students that met the criteria for those qualified scholarships.
Right. But these rules will apply to the years forthcoming. Am I correct?
That is correct. For
Okay.
26, 27, the law very clearly states in that second year that prioritization does take effect. But this year, it was a different criteria in the review of those applications as well as awarding those scholarships, I'm sorry.
Okay. Thank you for that. So what will the criteria be for next year?
Looking at the law, the way it's written is, of course, the first criteria is anyone that had a scholarship last year, as long as they continue to be a Tennessee resident, as well as citizenship or lawful presence, then that's the first tier for prioritization. The second tier actually is for any annual household that does not exceed 100% of the amount required for a student to qualify for free or reduced price lunch. And then also within that same criteria is the ESA and the IEA eligibility requirements. And then the next tier would be back at the 300% of the income. And then the next tier would be those students that are just now entering kindergarten, are currently enrolled in a public school. And then the final tier would be anyone else.
Thank you for that.
Yes, sir.
And regarding that, wouldn't it have made sense for us to track those individuals, because this is track those individuals that already have their children in private schools, because it speaks directly to the administration of the program based on the criteria that was set out for who's eligible and who's not eligible. Does it not, or am I off base with that?
Recognized.
Emily Cornude, Director of Legislative Affairs, Tennessee Department of Education. So Representative Parkinson, it is correct that we did not track that information. It was not a question on the application this year because the legislation did not require it. However, next year, this next cycle's application will have that question on there because it is one of the criteria set out in law. So we did not track it this year because it was not an eligibility requirement. However, because it is a prioritization requirement moving forward in the program, it will be a question on the application.
Okay, and last question, in regards to the textbook rules, or the fact that there are no textbook rules in regards for the private institutions. If any school that is a Category 3 or Category 4 school that would apply to, am I correct? There would be no rules expected in regards to what textbooks they approve or?
There are rules regarding any kind of curriculum and instructional requirements for non-public schools. They are not in this particular rule, but they are in our non-public rule.
And so does that cover divisive concepts in those rules?
My understanding of the prohibited concepts law is that it only applies to public school districts and not non-publics.
Okay. And then if a private school that is Category 3 school was to open up, let's say Nation of Islam decided to open up a school, right, under Minister Farrakhan. And so that means that they can teach anything, whether, this legislature deemed it divisive or not. Am I correct or incorrect in that?
They would have to meet the requirements regarding instruction that are set out in the non-public school rule.
Right, correct. But there are no instructions set out in the non-public school rules that prohibit divisive concepts. Am I correct?
That's correct. The statute specifically calls out LEAs as the scope of the prohibited concepts rule, but it does not mention or include non-public schools.
Okay, I just want to be clear on that. So the FOI or Nation of Islam, they could open up a school and teach things as they see fit to teach them without any intrepidation or without any backlash from the state of Tennessee.
We can't take religion into consideration when making decisions about which schools should be approved. Let me clarify that to say we can't discriminate on the basis of someone's religious viewpoints.
Okay.
So
Thank you.
if you apply and you're a religious school and you meet the criteria, you'll be approved.
Okay, thank you.
Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. Is there, and good afternoon to you. Is there a cap on the amount that an individual student, lifetime cap or per grade?
I believe, I'm trying to pull up the exact wording in the rule, but I believe it states in there that it can only be used, I want to say 13 years? 13 years.
13 years. So if I got in the program in the 6th grade, would I still have 13 years?
When you graduate from high school, and I apologize if I misheard you, when you graduate, you would close your account. Your EFS account would close at that point. So you would no longer be in the program. Did I mishear you? I apologize if I did.
Well, I'm not sure if you did, but I appreciate your clarification. If I'm repeating each grade twice, am I going to get money every time I repeat the grade?
I'm pulling up the language in the rule, but I believe the answer is yes. Give me 1 second. I'm trying to find the 13-year. Hold on. Okay, I found it. Thank you for your patience. But the rule states that a recipient's EFS account will be closed and all remaining funds will be returned to the state treasurer if the student completes 13 years of school as a kindergarten through 12th grade student.
So that would make clear that if it was someone who started in the 6th grade, they would have completed 13 years of school before they would have 13 years worth of payments.
And if it took me 13 years to get from 6th grade to graduation, I would still have that money coming in. I would still be eligible.
You will have completed 13 years of school before you will have 13 years of eligibility under this program if you start at the 6th grade.
Okay, now I'm kind of slow. I just told you it was going to take me 13 years to do those 6th grades. So could you just say yes or no or somehow simplify it? if I'm moving from the sixth grade to graduation, would I have a cap on how many years I would be receiving the money between the sixth grade and graduation? Or would I have the full 13 years left?
Representative,
And the sixth grade is what I'm coming into.
that's when
the
you're coming
voucher
in, right? So if you failed one grade, you'd have what, 7 in there. So there's but what it says is completed 13 years of schooling, which means your senior year plus 1. So once you've completed 13 years of schooling, that's that. It's not 13 years having received that amount of money unless you started in kindergarten.
So I could spend a lifetime getting my high school degree?
I think that would be precisely the opposite of what I was just saying. It's a cap. In other words, you stop receiving this after you've been in school for a total of 13 years. Not that you've been receiving the scholarship necessarily 13 years.
Oh, okay. So if I fail a grade, I could end up with being kicked off the program my senior year. If I'm
Are
in
we
the
still starting in
program
sixth
for
grade?
a full 13 years up until then.
Are we starting in 6th grade in this particular?
No, sir.
Okay.
We're doing 13 years.
Okay.
And my 13th year of completion, I'm in the 11th grade.
If you've let's see, what is it? It's 13 years of total schooling.
That's correct. It just specifies in the rule that once you've completed 13 years of school, your account will close at that point.
Okay, so to be clear, I could fail a couple of grades and end up being kicked off the program before I receive my diploma.
I'm not aware of any instances. I'm not an educator. I'm a lawyer, so don't hold me to it. But my understanding, students are usually retained, if anything, for 1 year. But to have a student retained 2 or more years is not common or usually in the student's best academic or social interest.
But this student would have started in kindergarten, you're saying, and
Yes,
then been
sir.
retained twice.
But you're saying it is possible.
I'm happy to check on that
I
and follow up
appreciate
with
that.
you.
And the others are pretty simple. Ride share costs covered here. I know it spoke to commercial transportation, but would that include Lyft and Uber, things like that?
I'm going to ask the department to speak to that.
The law very clearly, I'm sorry, Trudy Hughes, Department of Education Assistant Commissioner. When it talks about how the funds can be used, first and foremost, the prioritization is for tuition and fees. But as you go through and you look at the way the funds can be used once the tuition and fees have been covered, I'm looking through here and I see fees for transportation. The way that would work, that vendor would have to partner with the department to become approved to provide those services. So it would be a pre-approved service because they would actually have to apply to the department to become a service for this program.
Okay, so that has the department looked at the major ride share programs like Lyft and Uber? Or is that going to be on an individual basis? Each family is going to have to go through that application?
It's up to each family to decide how they would like to use their EFS funds. If they do want to use them for transportation, they are certainly allowed to do that as long as they follow the procedures outlined in rule and in the department guidance.
All right, and would any of these dollars be eligible for reimbursement of or upfront costs for field trips?
No, I'm happy to read what the funds may be spent on, and that is outlined in
Okay, I've
statute.
read that.
Okay.
That's why I'm asking for clarification.
No, it doesn't cover field trips explicitly.
All right, and my last one, I think, is speaking to the assessments. And you're taking a statistical sample as opposed to all of the students. Why is that?
The legislation just requires and only authorizes, I should say, the collection of data from recipients in the program. So if there are students who are already in the non-public school and that non-public school is giving those student assessments, that is outside the scope of what the statute requires to be collected. Only recipient data is being collected.
Yeah, I didn't understand that.
I
So if
apologize.
I'm a recipient, am I going to be part of that statistical sample or not?
You might be, but it's a sampling. So you might be selected for it and you might not. Again, I'm not a statistician, I believe the word is, but I will defer to my colleagues if they want to add anything, but that is my understanding of how the statistical sampling works.
A lot flashed for a second there. Emily Cornute, Director of Legislative Affairs, Tennessee Department of Education. Representative Hardaway, I want to make sure we're getting you the answer you're looking for. Would you mind repeating your question one more time? I'm so sorry.
Mr. Chairman, I'll get with them afterwards. But I am concerned that we don't have all of the recipients represented. We only have a statistical sample. And I think you said, or the language says up to a 95% confidence level, and we're getting 100% confidence level if we have everyone included. I just don't understand why we're doing statistical samples as opposed to the complete population.
That is
So
what
I'm looking forward to hearing back from you.
I
All right, now,
apologize.
if you
I didn't mean to.
you can go ahead, but I
interrupt.
might ask you another
That's
question.
fine. I'm happy to
Okay.
chat. The legislation, the public chapter, outlines the requirements regarding collecting of the data. And because the state board is not authorized to go outside the scope and add additional requirements to the program or to the private schools beyond what is absolutely required by the authorizing legislation, we don't have any legal authority to collect data other than what we're directed to in the public chapter.
Okay, I'm going to respectfully disagree.
Okay.
If your floor is 95%, that's not your ceiling also, is it? As far as the confidence level?
That's correct.
Okay, so
But,
you could collect 100% of the assessments for the students.
Again, I think any requirements that go above and beyond what is in the public chapter is outside of our scope legally.
Okay, I thought you were going to help me interpret. Mr. Chairman, I'll get with them later.
Thanks. Thanks, sir. All right, our list is complete. Do I have any public comments?
Motion for a positive recommendation.
We have a motion and a second. We do not currently have a quorum in the Senate, so Mr. Clerk, we're going to go ahead with the House here. All those members in favor of a positive recommendation indicate by saying aye.
Aye.
Any opposed?
No.
Would you please have your votes recorded? All right, the rule moves out with a positive recommendation from the House.
Thank you, Mr. Chairman and members.
Yes, sir. Thank you. Chairman Crawford, you're recognized, sir.
I make a motion, we adjourn.
Without objection, we are adjourned.
I like to just put all approved or whatever at the top, so we go back through in January.
long ways removed from the statistics class, but I don't think either one of them were on point with what's in there. It said, turn your. All right, Mark. Statistical analysis.